become, and like I said, the interesting thing is the way the CAPC tax applies to this. In other words, you sign a lease for a year and you're leaving 29 days, according to the code, according to the regulations from the state under the CAPC tax, you got to pay. And that was a big shocker to me. But I think, like I said, the issue is here whether it's a true landlord-tenant relationship as opposed to, a transient. And what we're dealing with here is, we're dealing with, as has been said over and over again, we're not dealing with just transients. We're dealing with tourists and people who are renting their homes out illegally in violation of code because they didn't get a CUP, and they didn't get a CUP because they can't get a CUP. And that's why they dreamed up this, loophole, which they, want to use as an argument to legalize what's illegal. We allow dwelling units, it's in the code, where do you have to, it doesn't come down until you reach the bottom of the code where you have commercial headings. That's where it's permitted. And if it's permitted there and it doesn't list it under the residential areas, they can't engage in tourist lodging without a CUP. And in Victorian residential, they also have to comply with the 200-foot rule, which is why certain people here ran down, and that's solely to get around this here. I can get around the 200-foot rule. I don't need parking spaces here if I'm a weekly rental. And I guess in the future, you know what I'm saying, maybe there should be, like I said, just plain old enforcement, and maybe there'd be, there should be some maybe additional reporting requirements here as to, to determine who these people are. But the best news is that these people have already identified themselves. Who are they? They're the people attached to Appendix A to this ordinance.
Okay. Thank you.
Further? Mr. DeVito?
I would move to eliminate item number 2 from unfinished business.
Okay.
Second.
All in favor, say aye.
Aye.
Any opposed?
Oops.
No.
Okay.
No.
Are we done with the discussion?
Oh,
Yeah. Well,
You had your hand
I
up,
had my
didn't
hand
you?
up.
He had his hand up.
apologize.
He voted.
Okay. Yes, I would like to make a motion that we acknowledge that these licenses that are in question were granted in error and in violation of the city zoning code, and direct the city clerk not to renew them.
Second.
They're not in violation of the city code, though, because they have the right, anybody has the right to get a business license. It's a tax. It's not a permit to do anything. They may be operating in violation if you take the way you're referring to the code, but a license is not a permit to do something. It's a tax. And you can buy a license from the city to do an illegal act. That does not make it a legal act. If someone wants to open a marijuana dispensary in the middle of town and they don't buy a business license, which it would fit under this same category most likely,
They can't get an R1 or R2.
well, if they open one without a business license, that's simply another offense. It doesn't give them the right to operate a medical marijuana dispensary in the middle of town in violation of state law, but if they don't buy the tax, the license, they're not allowed to operate, not only because it's illegal to dispense marijuana in this state under the state law, but it's also illegal to operate a business without a license. So they're committing multiple offenses instead of a single offense.
That's not my opinion. Okay.
okay, sir, you have to
I
be
want
called
to
on by
hear,
council member.
yeah, I'd like to hear what he has
Right.
to say. Thank you.
All right. And this is here stating from Rathkoff, the Law of Zoning and Planning, Volume 1, page, from 1964 edition. A permit issued for a use or structure which is forbidden by the ordinance is beyond the power of the officer to issue. Consequently, it has no legal status, is invalid, and is itself entirely without power to clothe its holder with any legal rights thereunder. And that's the general textbook opinion of it. And it really doesn't really say anything different than what your attorney just said.
So,
In other words, you keep the $50.
so does this mean that these licenses are invalid?
Well, what it means is the only issue here today is whether or not they're entitled to a refund. In other words, from what I understand of the law, and it's not just this authority here, so there's also that if the permits are invalid, really, they're probably entitled to a refund, and they're definitely, and there's also a law to the effect, too, that this is a renewable license, too. So, when it comes time to renew it, just you say no. But like I say, it's totally invalid, and really, they should be given a refund and told that, sorry.
Any further? Ms. Lindblad?
Yeah, so that says that the licenses are invalid, period.
They're void, totally void
They're
from inception, because under the law, the clerk had no authority. The clerk has no authority to issue an invalid license.
Okay. Thank you.
It's not an invalid license if it's issued under a color of law that is possessed in our ordinances that allow 199 any business.
But that's just a fee schedule.
It's a fee schedule, it's a tax. It's not a permit to do something.
Ms. Lindblad?
So do we have a disagreement here? You're saying that licenses are valid. He's saying they're not valid. Is that what's going on here?
No.
What's going on then?
Good. You want to respond to that?
I
Yeah.
have a question.
What?
Okay, well, hang on. Mr.
Certainly.
Well, there was a question.
Yeah. He's got to give an answer first before we can jump into the other comments there.
It's not a question of whether the license is valid. The issuance of the license is valid. Whether it bestows upon the holder of that permit to do anything, it doesn't. That they can't do. Except to avoid being criminally prosecuted for operating a business without a license.
Mr. Raphael, had your hand up next, sir.
Yeah, it seems to me there's potential lawsuits on both sides. I think our code's strong, and I'm going to stick with it.
Ms. Ballance.
Just for information, I would like to know where Mr. Jasinski is registered to practice law.
Nowhere.
Nowhere?
Well, I'm reading from
Thank you, sir.
legal text. I'm not getting
Thank-
any legal
thank you,
text
sir.
of the city.
Mr. Berry.
I guess this is Mr. Weaver. Is it similar to me writing up a deed to a piece of land that doesn't exist and then file it with the tax assessor and then them sending me a tax notice and I'm paying the taxes on it? Even though the land doesn't exist.
Even though the land
They
doesn't exist,
will accept my money.
If you voluntarily pay the tax,
Yeah.
you're not
they will.
entitled to a refund.
And they would send me a bill for that
Now,
non-existent.
if
because
you,
I've-
if you then
because I've
try to
formed a-
convey that to someone else, you've committed fraud. But yes, and so if one of these holders of the permit that should then try to purvey what they perceive is their property, being the right to do something, they would be in violation of a fraud statute. But you can voluntarily pay for a license, whether you operate a business or not.
Mr. Hunter.
Two-point question. Number one, it's my understanding that these businesses should have gotten a CUP, and if they hadn't been approved for it, then the license would have been appropriate, the way I read the code. Secondly, if we go on with this ordinance the way it's currently written, then we're approving spot zoning, which we should not be doing whatsoever. Is that not correct?
I'm sorry, but I don't follow your logic. I don't see where you're
We
going.
change allowing a non-permitted use that requires a CUP, then they would have been legal had they been approved, or been able to have been approved. Nothing saying from what I've read or understood that any of the 10 could or could not have been approved for CUP. The second part of that, if we proceed with the ordinance and pass it, then we basically approved spot zoning.
No. And in reality, that is taking the opinion in the way that it's been turned. That is saying that you can provide tourist lodging if you want to for 7 days. The way our code, if you leave it the way it is, does not restrict from renting your property for 7 days or any period that you want to. 7 days is the common, and to use the term that's been thrown around that often slumlords use, to rent apartments and or residences. And so that's still a legal use under the way you're leaving the code. Only our taxing structure under the CAPC laws require that you pay a tax if you're renting for less than 30 days.
That doesn't preclude you having to follow the rest of the rules.
That doesn't make you a tourist lodging. If you are renting as a landlord tenant for 7 days at a time. You're not increasing in tourist lodging.
Any further? Mr. DeVito.
What's,
Call for the question.
well, I had my hand first and was recognized. What's the motion on the floor?
Take it off the table.
Well, that was my motion, but then Mr. Parker made a motion, so I just wonder where I fell in all of that.
I'm going to say not instruct, but request that the the clerk not issue any more licenses. Correct?
To get the city council to acknowledge that these licenses were granted in error and in violation of city zoning codes, and to direct the city clerk not to renew these licenses. The ones on the opinion.
There's already a motion on the table.
That's
That was
the most recent
my motion.
I got one ahead of you.
Ms. Lindblad seconded that motion.
Right, but Mr. DeVito's motion come first.
I would like to amend my motion
Okay.
to refund the fees paid as per, what was it, $199?
Go ahead.
I have a procedural question. Since Mr. Raphael's motion followed Mr. DeVito's motion,
It's not valid.
pardon me?
It's not valid. My motion supersedes his.
But you took a vote on yours.
No.
No.
She just seconded it. It's not been voted on yet.
Took a voice vote. And then Mr. Raphael pointed out that he was trying to get discussion in place.
I
call a
have
vote.
no memory or recording of a vote on Mr. DeVito's.
No, we didn't.
No.
Didn't.
He was trying to close it out, and I reminded him that there should have still been time for discussion.
To your motion.
All right, so the original motion goes back to Mr. DeVito.
And I'm wanting to amend my motion to instruct the clerk to refund the permit fees to the 10 parties who have paid them. Period.
Is there a second?
Couldn't we combine the two?
Well, let's get a second and have a little discussion on this.
Second.
Okay. Now, the floor is open for discussion, Stan. Go ahead.
I hate to use your verbiage because it brings in all other things, and I'd like to keep it simple and just refund that. And we've pretty much all achieved consensus that the best thing to do is nothing. So I would at least like to have that action of refunding those because they inadvertently were allowed to give us money. And I think as a good faith gesture, we'll just refund their money.
I think that's fine, but what happens when they come in to renew their licenses?
They don't get one.
Is that stated anywhere?
Well, there's no qualification for allowing them to have a license in the first place.
Correct.
Go ahead. Say something.
I concur. And since I'm the one on the firing line, that's...
Ms. Ballance.
If, as the city attorney has indicated, these licenses do not confer anything except the right to collect taxes, the right to submit taxes,
They don't even do that. They are a tax.
why would we want to refund money from the city for licenses that were bought that don't mean anything? I mean, truly it would be a goodwill gesture, but golly, we pinch pennies and do other things that really are not necessary to bring in a few extra dollars. I'm just kind of confused since the city attorney says that these licenses don't really mean that people can actually do businesses under them. It is a tax vehicle. Why do we have to do anything about that? Why can't we let them renew them ad infinitum every year and every year? That'd be a little more income. They can't use them to do what some people are alleging these people want to do. What's the purpose? I just don't understand.
You going to respond? If not, Mr. DeVito, you're next.
People receive bad information to start with, and it started with this CAPC under 30 days thing that people misunderstood that somehow entitled them to rent their property in conflict with our regulations. They came to us in good faith thinking that they had to abide by our laws and start getting licenses and collect these taxes, when in reality they did not have that avenue appropriate to them, and their money was taken. They probably understood that they were working within the law, and the clerk, as we all understand, we're all just finding all these nuances and all these other regulations and how all this fits in, and it's hard for anybody because we've got attorneys that are finding out all these things about our code, and I can't imagine that the city clerk would have all of this knowledge at her fingertips. So she interpreted that as the $199 to give them a license. So they came to us in good faith thinking they were having to abide by the law, when in reality they had no standing. And I just think it's a good faith gesture on our part to give the money back. I would feel remiss in holding their money, thinking that they were granted some favor by it, when in reality they have no standing by law. So I just think it's a goodwill gesture on our part.
Any further? Okay. Ms. Ballance.
Just for clarification, I would like to hear the city attorney's opinion on what's trying to be pushed through and the legality of it.
I don't think you have to refund their money. I don't think you are prevented from refunding their money. But you're still leaving the ability for them to continue to rent just the way they have been, and they are supposed to be collecting a tax. And if they're running a business, they're supposed to have a business license.
Thank you.
Anybody else? Okay. Back to the original motion.
Well, the third motion.
Okay.
I amended my original
So, okay, so the motion on the floor now is Mr. DeVito amended the motion to instruct the city clerk to refund money to the 10 people. Mr. Berry seconded. Any further discussion on it? Ms. Ballance?
I'm going to have to vote present on this one because I'm not sure that what's trying to be done is going to protect us from any kind of lawsuits from either side. So since I'm not quite sure of the legality of it, I'm going to have to vote present, because that's what I do. When I'm not sure if things are legal, I vote present. Thank you.
Mr. Pownall, you had your hand up, sir.
I just think that if we go along with the voluntary refund without the appearance of anything other than that we're still condoning what they've done. I think that also the license that has been issued ought to be revoked along with the refund if that's the way we go.
Mr. Weaver.
Just to clarify what I said in response to Ms. Ballance, I'm not saying that these people are supposed to be out there renting to tourists. I'm talking about a landlord-tenant relationship. And that there is no restriction in our code that prevents you from renting in a landlord-tenant relationship for a period less than 30 days at this point.
Mr. Barry,
I'm curious as to exactly how did the license that was issued by the clerk read? Did it read on a transit basis or tourist lodging? How did it read?
Something, businesses and services not otherwise listed.
No mention of lodging at all.
Not it.
And you sell licenses of that nature to other businesses besides these 10, correct? Several other businesses that don't fall into one or other of our other categories.
Correct.
Well, it's a matter of enforcement. And the building inspector will go around and determine if these people are legally conforming to our regulations. And if they're not, they'll be cited. And there's citations written in the law.
Mr. Penna.
Just one final clarification. That it was stated in this whole issue that in the code it says no lodgings are allowed in R1 and none in R2 without a CUP, and the code says that where the more restrictive standard applies, then that's the one that shall be gone by, instead of the weaker of the two. And I believe that's what the code says. Is that not correct?
You're taking lodging to define, though, I think in the broader sense of tourist lodging, not as rental in a landlord-tenant. That doesn't restrict landlord-tenants to a particular term of lease.
Mr. Barry.
I'm not real comfortable with the James's amendment, mainly because of what the clerk said, that she just issued these licenses as a blanket 99 license. I go back to my question that I asked the city attorney, and I said that in good faith because my granddad actually deeded my brother a piece of property that started in Carroll County. It was supposed to be inside the city limits of Eureka Springs, but by the time he ended up with a legal description, it described a piece of Madison County, and it was filed with the clerk as a piece of 1 acre property and assessed as such, and he paid taxes on it for 10 years until the surveyor said the property doesn't exist. So again, what happened, he voluntarily paid that tax because, you know, he just did. And I think the same thing with these people that have bought their license. They bought a license. If they want to take it and put it into their landlord-tenant relationship, then that's their privilege. And I'm more comfortable with just trying to stop this where we are right now and maybe making sure somehow we address to the clerk not to issue any lodging permits that deal with transit or with tourist lodging.
How could that be assured?
By having them document in writing that they are only renting rooms for transient guests and not for tourist lodgings, and these can be documented by the websites. People advertise on websites, this is for tourist lodging. Transient lodging people don't go to websites looking for, I want a place to stay for 2 weeks. I'm a roofer, I'm a painter. They come into town and they usually end up in a motel. So I think it's going to be pretty obvious on there. Mr. Bob, I'd cede some time to you.
hate to burst your bubble, but, I provided you with this memo here. If you go to page 3, unfortunately, the way the code is worded, you cannot even rent to anybody, because the first time you get permitted uses for a dwelling unit which permits weekly rentals is under District C1, Victorian Commercial. That's the first mention of it. And then you go down there, you can also do it under District C2, Contemporary Commercial, on page 4, and you notice that's the first time where they have a permitted use dwelling single family, dwelling two-family, dwellings multi-family, and then under it in bold, dwelling units contained in a commercial building. So actually, under the code, it might appear, that you can't rent your room out by the week to even non-transients. You keep saying transients, but you mean non-transients, people that do intend to stay here. So that maybe should be changed a little, allow people in single-family residences, like people in college towns that rent out rooms. I rented out rooms when I went to college, and nobody seemed to object to that, but that was long-term. That was for the full year of school. But the way the code is worded, they can't do it in R1.
If you take that reading, you can't rent any house, apartment, or anything in R1.
I didn't write it.
Further? Mr. Raphael?
Well, that was kind of the point of the code that covers R1, is there's plenty of places for people to rent in this town, lots and lots of places. But preserving some of the neighborhoods that are not being rented out or having business, they're gradually shrinking. And I think that was their point in which, was it 1880, the Ordinance 1880? I think that was their point, is to preserve those neighborhoods. There's plenty of places for people to rent.
So you're taking the stand then that anyone renting month to month or even 6 months at a time is violating our code if they're in R1. Because that's what, if you take the way he's reading it, in that vein, that's what that's saying. That you can't rent property in R1. You only can buy and sell.
Sounds good to me.
Ms. Lindblad.
All right, so just very briefly, what would be a solution that you would suggest? I'm just curious.
I think you need to establish, if you truly don't want a lot of in and out in R1 or R2 or even R3, that you need to establish a minimum monthly time period that you rent property to tenants as landlords. And if you don't if you think that that's going to discourage long-time residents who do rent by the week, then you've got to put up with a broader reading.
So you're saying that, sorry.
Go ahead.
So then where does that leave us if somebody moves here long-term, they think they're going to be here long-term, and so they're here for a month or 6 months or a year, and they decide it's not for them, or they can't find a job, or their mother gets sick and they have to move back to wherever their mother is, and so they cannot stay for that full time, the month or the 6 months or the year. Where does that leave the landlord or the building owner in that situation? They'll be in trouble because these people, through no fault of the landlord, these people moved along. So then the landlord is not in compliance with the code, and they're in trouble through something they had totally no control over.
No. Landlords typically receive their rent at the beginning of the month. And if you break your term of lease, the landlord retains that money. So if you rent a house for 30 days as a tenant, and at 25 days you decide you're going to move to Anchorage, Alaska, you lose the other 5 days. The landlord has rented the property for the 30 days.
Okay, so then the landlord can't go in the people have stayed 3 weeks. The landlord can't go in right away and rent that back out again. He has to wait another week.
The operation of law doesn't allow it to.
That's really restrictive, I would think.
That's state law.
Ms. Lindley.
So are you suggesting that the way that what you're talking about could be fixed is that we would say that perhaps a place cannot be rented for less than 30 days?
I think that would be a solution to what's going on. But if there are properties that are already being rented on a landlord-tenant basis, you can't get rid of those by that. And that was the intent of the list, was for this council to be able to determine what properties fit that definition of landlord-tenant at this time and have been in compliance. And if they are not in compliance, they don't deserve to be on that list.
So, in other words, if they're on that list and they're renting weekly and it says that you can only rent for 30 days or more in R1, then that invalidates those people who are renting weekly?
No, if they are already in existence when you would pass the ordinance, you would have to leave them as non-conforming.
But if they're not, they don't have a CUP and they can't...
CUPs have to do with tourist lodging in this instance of what you're talking about. I mean, you can have CUPs for other purposes, but you're not grandfathering them to rent to tourists. They would still be grandfathered or non-conforming use only for landlord-tenant purposes, not to willy-nilly rent to everyone that wants to come here and spend 7 days of vacation time.
How would you determine that?
It would become a legal question that would probably end up in court with somebody being prosecuted for violating that by advertising on a website.
Sure, DeVito.
Well, don't forget the distinctions between residential and quiet commercial and things like that. We want to ensure the sanctity of our truly residential neighborhoods, and if there are properties in those neighborhoods that presently have landlord-tenant relationships, then we will probably have to amend the code to allow a minimum of a 30-day rental if those are already existing, and get rid of the weekly in that case. There are other avenues for weekly rentals in other zones. It's not like there's no properties in the city that these people can find a weekly rental. There are. So we just need to focus on our truly residential neighborhoods, and we'll find out if there are. But right now, there's no requirement for those people to even show up on our radar screen.
Actually, there is right now, because they're supposed to be paying our CAPC tax if they're renting for less than 30 days.
Less than 30 days. I'm saying 30 days or more.
Yes, but I mean, even if they're renting for the last 10 years, if they've been renting week to week, under our current CAPC tax, they're supposed to be paying tax.
Correct.
And that would be where they would show up.
Oh, no.
So if I have a house in in a residential district, R1, C1 commercial, R1 Victorian, and I'm renting it out properly, is that considered a commercial enterprise?
Well, that gets back to whether you're taking Mr. Raphael's and the last comments from the gentleman here. Maybe they're not legally renting anything in R1. But if they're renting, it is a commercial business. I mean, as far as renting property, that's a commercial business. Tax codes tell us that. I mean, the IRS don't let you rent out your property and not pay taxes on your rental income.
So if it's commercial, then the very first statement in residential district zoning regulations are intended to accomplish the following: protect the residential character of areas from noise, traffic congestion, and other adverse effects caused by commercial and industrial uses. So what we're doing is we're allowing a commercial use in an area where we say you can't have commercial business
No. No.
without proper approval.
Mr. DeVito.
That's an interpretation that I don't think is going to stand in the sense of a commercial like in a C1 or a quiet commercial. I mean, I have a house in an R1 district. There's no law against me renting it out for a year. And that won't qualify in what our definition of a commercial enterprise is.
Have you got a license from the city to do that?
I don't need a license from the city to do that.
Therefore, it's not commercial.
Any further?
But it is commercial.
Okay. No further, then we are back to the original 2 pages ago. Yeah.
Mr. DeVito made a motion to instruct the city clerk to refund money to the license money to the 10 people. And Mr. Berry seconded.
Okay. So your understanding is your motion has not been amended in any way. This is the way it's stated. As a second. Any further discussion, Mr. Ballance?
Was it the motion already on the table and seconded? We're not supposed to have 2 motions on the
He
table.
had the only motion on the table when Mr. Raphael come in with it. I think it was. He amended his motion, which was the one that held precedence at the table,
And
which
that,
overrode Mr. Parker's, Mr. Raphael's. So it's back to the original, now amended ordinance with a second from Mr. Berry, and that should be the one that should be addressed in a vote. So, with any further discussion? All in favor say aye.
Aye.
Any opposed?
Present.
No.
411.
Okay. So, the status of the, yes ma'am.
That's all the problem.
Yes, I would like to make a motion that the city the clerk to issue no further licenses
Mr. Weaver.
for weekly rentals.
They're not issued for weekly rentals. They're
Okay.
issued for 199 category. Other unlicensed or unspecified businesses. And if you instruct her to do that, she's got to stop giving them to all the businesses that are getting 199s.
All right.
And that is a real problem.
I rescind my motion.
Mr. DeVito.
I think it's clear from the discussion that we've had that they're not entitled, if they want to come back and get another license to hang on their wall with their family photos, then we can't stop them from doing that. But they have to understand that in no way entails them any rights under that.
Okay.
I think our directive now is to address the question of R1, R2, how we tighten up any regulations regarding monthly rentals or such, and I think that's something to go on the agenda for the next meeting.
Mr. Pownall, you had your hand up.
Point of clarification, with that vote, does that mean that the moratorium is now over for 199, where people that have another 199 business that is not involving lodging can get a license?
No, you would need to take a vote to do that.
We'd have to take a vote to rescind the moratorium.
Yeah. No, all you've done is authorize 10 refunds.
Further? I believe it was 10.
No, wait.
To 10 people.
Right, that was the 411. Yes. Thank you.
No.
Based on that response and without exact numbers needed, are there a lot of other licenses being held up for other businesses?
No.
Other than just the lodging ones?
There would be no harm in maintaining the moratorium until it expires.
Any further? Okay. I believe we move on to the next issue.
Did we clear all motions that were on the table?
I think so. I think that one was the only one on the table, and it was voted on.
I don't think so. I think mine was on the table and seconded.
Mr. Parker's motion prior to the third, on which was the one on which was vote was just taken. Motion to have council acknowledge the error and direct the clerk to not issue any more licenses for
the people that are on the appendix.
Appendix A.
Appendix A.
Whoa. Point now.
No. That becomes a big point because they can come get a 199 for some other business, and if you say it the way you just said it, you're taking a property right. We're going to be in court tomorrow.
That's why I made my motion.
Better way to say it.
Was there not a previous motion by one of my colleagues to take this off the agenda?
Yes, that was the first of the three.
Have we processed that yet?
That was amended.
That was amended to this last.
So we don't have to vote on the main motion? I thought generally speaking you voted on the amendment and then you voted on the main motion?
He took the other. My understanding was that Mr. DeVito took the original motion off and made an amended motion in place of. But I stand to be corrected.
That was my intent.
Okay. So does this need to be addressed any further, or do we move along? Ms. Blaine?
So how could that motion be made, Mr. Weaver?
I don't think you can make that motion because we continue to issue 199 to anyone that doesn't fit into another category. And we don't necessarily, as I understand it, ask them what they're going to do with it. Subject to the clerk telling me different. I mean, when they come in and they want a 199, do you ask them specifically, what are you going to do in this business?
That question determines the category. So yes, each person is asked, what are you planning to do?
And if they say something that's not in one of the categories, you question them further?
Right, the fellow who wanted a license for an Orbitron. There's no category for that, so he goes into 199.
Okay. But if they just come in and say, I don't fit any of the other categories, I want a 199, what's your response?
I've never encountered that, and after going through this, I am going to put a neon...
Nope, can't do that.
I'm going to put a neon note in
Couldn't resist that.
the code book so that all future city clerks don't have to go through this. Ask these questions and don't issue.
We don't have an ordinance that allows you to ask that question, I don't believe.
Well, that's the only way we can determine what category they go in.
Yes, and they are required by law to buy in the proper category, and you can assist them in picking a category. But if they simply say, I want a 199 business license, I don't think there's anything in our code that provides for you then to ask them, what are you going to do?
Is there anything in code that allows me to say there's not enough information and I'm not going to issue the license?
No, there's nothing that permits you to make a determination what they're going to do.
But in practical application, the person who is in that office has to make the decision.
Why?
Point of order.
I'm sorry.
Point of order. We're off the field.
Okay. Next in line was Mr. Pownall, then Ms.
Move
Ballance.
for a 10-minute break.
Is there a second?
I'll second it if you'll let me ask a question quickly.
Conditional use.
Discussion.
It's called compromise, something we've not seen a lot of at this table this past 2 years. I keep wondering, when I was at home sick after I left the last meeting and we were all talking about this, I kept wondering, why don't we split this specific license out from the 199s? If it's truly going to be something that is going to be something, why don't we split it out and have a separate category for that specific use instead of lumping it in with all the other 199s? What is to prevent us from designating new categories when new uses become apparent?
Mr. DeVito.
That's not a category. Simple enough.
What's not a category?
What is we've been talking about for the last hour is not a category.
Well, okay. Hypothetically, any of those.
Recess, 10 minutes.
Second.
Okay. You want to respond to any one of those? You can do that when you come back.
Well, you could create a category for landlord-tenant operation. And that would then cover everyone that is renting property.
Yes, sir.
Before we bury this, does a licensee come in, or do they even have the right to come in and say, I want a particular license, i.e. a 199, without telling you what the business is? Because if they can, I want some of that.
I wouldn't issue the license.
Like I said, if you want to hang it up on your wall, give us $50.
All in favor of the recess, say aye.
Aye.
Any opposed? 10-minute recess.
Any rights?
We'll be back in session with a 10-minute recess. We are currently on number 2, unfinished business, discussing ordinance 2167, second read. Motion to discuss. Mr. DeVito.
I'll make a motion to remove this from our agenda.
Second.
All in favor, say aye.
Aye.
Any opposed? Motion carried. Brings us to number 3, unfinished business, city attorney review on the auditorium agreement of 2013.
Move to discuss.
Second.
Second.
Who's going to jump in? Mr. Weaver?
As I understand where you left this a couple of meetings ago, you were wanting to know whether there is a binding agreement because no action was taken to prevent one from automatically renewing based on last year's contract. That's the question. I'm prepared to answer it, but I want to make sure I'm answering your question. So I guess I'm directing it to Mr. Pownall and Mr. DeVito since they're the two that put this on.
My question is, was our contract properly written to start with based on what has been discussed? Because the very first paragraph says that the agreement is in effect for 1 year ending December 31st, 2012, comma, until amended by agreement of the parties. If you read just that, then I would assume, I don't know what happens when you assume, that all the terms, the $94,000 plus profit margin when they pay back money to the city would prevail, or secondly, it says, while this is a year-to-year agreement, continued without notice between the parties, either party may terminate the agreement by giving him 90 days written notice of intent to terminate. And the last paragraph in 3, agree to honor by payment any contracts for not more than 1 year in length signed by the CAPC in the normal course of management. And I think that was when we discussed the original intent behind approving this agreement was so they could make long-term commitments, but I don't think, and correct me if I'm wrong, I'd have to go back to the agendas in the past where we attempted to have this discussion, which to me shows an intent by this table to have further discussion in regards to the 2013 agreement. That was my question.
If I understand your question, I believe you have an automatic renewal in place. Your intent may have been to terminate the contract, but that is not what was expressed from what your question was just now. Even you said the table showed its intent to have further discussion. This original document, original contract, provides that there can be changes, and those changes can be done by mutual agreement of the two parties. So you could have been having discussions about what term do we want to change, and you could still have that because both parties can enter into a change now, June of next year.
But if it's currently in force, then the terms are still in place because there has not been any discussion, correct?
I don't see any legal change, no. Because you have not agreed to the legal change.
Yes, I'm sorry.
Does not, and I direct this to the city attorney, does not putting an item on the agenda for discussion show intent on one party's behalf of a contract to discuss something that is coming up?
You would have to...
i.e., I move that we put discussion of the 2013 City CAPC Auditorium Agreement on the agenda as an intent to discuss it, that there are issues, and I believe even one of our newest members questioned where we were at that point in time, that we were still able to discuss the 2013 agreement. And contractually, that's what I have a hard time swallowing. Our intent was to have discussions regarding, and I believe it was discussions in regards to the mayor having discussions with the CAPC in terms of the 2013 contract, which would have then, had it stayed or been on the agenda, we would have gotten what they were proposing to do. We want to leave it the same, we're doing okay. We aren't doing okay because maybe our utilities are too high or whatever the case might be. And I'm concerned with the fact that our intent was shown to have discussions on this agreement were made by putting it on the agenda, whether it got acted on or delayed, and then all of a sudden we've got an automatically renewed contract.
What the question would come down, was your intent clear, one, and two, was it properly conveyed to the CAPC as the other party to the contract? And I'm not prepared to tell you that your intent was clear or not clear. That would be a determination you would have to make, and this body would have to make. And two, was it proper notification to say we're going to discuss it at this table? I think it's pretty common knowledge, but is that proper notice? Not necessarily under the terms of the contract.
Yes, go ahead. I'll keep reading through this. I'm sorry.
No, I was concerned about this when I found out that the mayor had been under discussion that it was being changed to a 3-year contract. I have no problem at all with a 1-year contract, but I didn't like the idea of a 3-year contract. It's already written in there year to year, and nothing changes as far as I can tell unless we choose to change something, or the CAPC chooses to change something.
Actually, unless both parties choose to change it. Because it's got to be by agreement of both parties.
But that's the part that I was objecting to, is a 3-year contract. Suddenly it was going into a 3-year contract, and I'm pretty comfortable with a 1-year contract.
I think it was just discussion on the multi-year, I wrote it right here, multi-year agreement, which it didn't go that way. It's just a year-to-year still.
Because it's absolutely necessary that we continue because there's bookings and things going on. But
Stand by.
So right now, we have a year-to-year contract still?
Yes.
You have a renewed contract for another period of the original term.
So it was automatically renewed without us ever discussing any of the terms?
Roll over.
well, it's written in there.
Yeah. It's actually part of the contract that it rolls over if it's not addressed before that date.
Continued without notice.
Any further? Ms. Limbaugh.
So from what you were saying before, we could still change parts of the contract if we wanted to?
If they agree.
They have to agree to the changes?
You can't just unilaterally change a contract. Contract is a binding document between two parties. When you want to change it, both parties have to agree to the change.
Ms. Ballance.
So then is that to say that if one part or the other wished to terminate the contract, that would have to be agreed upon by both parties?
If the term of the contract is defined in the contract, yes.
Okay. That seems crazy to me. That's like if you got an employee that's working for you and they're doing a crappy job, you can't terminate them.
You can terminate them if you have a contract with them and your contract bears the terms of what the grounds for termination are. If you have no grounds for termination in your contract, you probably don't have a contract. You probably have an employment situation, as we do here in Arkansas, employment at will.
Mr. Pownall.
So if that's the case, the statement in this contract, the CAPC shall retain any rental fees and concession income earned in consideration of this agreement until our cost of $94,753 are met. Once that's hit, then everything else belongs to the city.
If the contract is simply renewed, which is the argument that is before you that it has, the terms remain the same.
That term doesn't say that that's based on an annual basis. It just says until they reach a point that their costs are $94,000.
I think under contract construction, you would find that most would say that that is a term per term of the agreement. But you could make that argument, yes.
Any further? Move along. Brings us to number 4. This is the Yellowback Research Committee.
Motion to discuss.
Second.
Second.
Floor's open. Ms. Ballance.
As the Yellow Bag Committee has been discussing the yellow bags, we've found that the contract is what the contract is, and we're not in compliance with the contract, but the contract can be revised with the consideration, with the approval of both parties. So we know that about that. When we look in the in our code book, we look at section 5.08.03, trash for pickup. Section A reads, no trash shall be placed on any public sidewalk or within 10 feet of the curb of any public street that has not been placed in a receptacle with a tight-fitting lid that is leak-proof. In a receptacle with a tight-fitting lid that is leak-proof. The receptacle should be fly-proof and insect-proof and sealed tightly enough to prevent odors from escaping. Cardboard boxes and similar containers shall be flattened, tied into bundles, and placed for pickup without being in a container. Section B follows to say residential areas. So obviously the first portion is talking about commercial areas. Residential areas are regulated